Okay, so Article 14. Say the state shall not deny to any person equality before law and equal protection of laws within the territory of India. Right? Now that is a very interesting point, that what is the difference between these two words? Now to understand the difference, one thing I will suggest that think about it as a what kind of law do we have? What category of law do we have? So we have primarily basically two category of law. First law, which provides for punishment. If you do this, that we say a negative law. If you do this, you will be punished. Right? Second category of law we have, that either incentivize you or give you some sort of benefit. Think of any law. It can be categorized into two parts. Either it is a negative law, it means it will provide for the punishment, or it will be a positive law which will be giving you some sort of benefit. Like for an example, any law, suppose this recently passed this protection bill, also this the bill passed one that was being tabled in the parliament, data protection bill, right? So what kind of law it is? Both, right? Provides for punishment as well as it gives you some sort of protection also, or benefit also, that your data would be protected, right? So ordinarily any kind of bill very at a primary level can be divided into two types. One is either giving you benefit, that is your positive, or either punishing you, that is your negative. Now these two words, that is your equality before law, has come up from the constitutional principle of UK, and it is always and always applicable in the case of negative law. It means if you are providing for punishment, then there cannot be absolute any kind of difference between the person to whom you are going to punish. But if you are providing for benefit, then what kind of protection is needed will depend upon the person who is getting that protection. So it means that socially disadvantaged people will be entitled to more protection, and socially good, non-disadvantaged people will be entitled to less protection. It means there can be some sort of discrimination, right? So in the first case, there cannot be any discrimination at all, and it is mostly applicable to the law providing for punishment, right? You cannot have a law saying that, okay, the punishment for theft would be different for male and female. You cannot, right? But when we are talking about protection before law, so the primary aim of law is to protect, right? And people in different circumstances will need different level of protection. So in effect, protection of law, equal protection of law is equality before law in equal circumstances. Protection of law, equal protection of law is simply equality before law in equal circumstances. It means that circumstances would be something which has to be considered. It means that there has to be some sense of inequality or discrimination that is accepted. So, absolutely speaking, Article 14 do not prohibit discrimination. What does it prohibit? Simply, it prohibits discrimination of the people in same circumstances. So, if the circumstances are different, discrimination can be done. Understood? Now, if the discrimination can be done, then what kind of limit you will provide for that discrimination? So, the court has come up with certain doctrines. If you are discriminating, these are the set of rules that you must follow. Getting my point? Understood? Now, what are those set of rules? So, those set of rules are basically what you can say is the progressive interpretation of the equality. Initially, they came up with a very good rule, very binary sort of rule called reasonable classification. It said that simply if you are trying to discriminate between two groups of people, then the purpose of discrimination, or very Latin word they use, that is called intelligible differentia, right? Yeah, purpose of the discrimination must have connection, must have a reasonable connection. Now, this word reasonable indicates it is the court who will determine that whether it is reasonable or not with the point of discrimination. Meaning, if you are discriminating and you are discriminating with regard to something, so that distinction and that something must have a reasonable connection. Like for an example, if you are providing a law which says if you have committed theft, and if you are a man, you will be punished for 5 years. If you are a female, you will be punished for 3 years. So what might be the purpose of the law of punishment? The only purpose would be that it should act as a deterrence. Now, what is the discrimination that I am giving? That is your sex. So, do you think that there is any connection between sex and deterrence with regard to a punishment? No reasonable connection can be there. But if I change that law and say, okay, if you want to marry And if you are below 18, then you will be not punished. I mean, above 18, then you will be not punished in the case of female. And in the case of male, if you are above, acha, ulta ho gaya, 21 and 18, right? You will not be punished, right? So if that is the case, so do you think the purpose of legislation is to prevent child marriage, right? And the discrimination between male and female, that is the ground is sex. Sex and child marriage has some relationship between them. Obviously, the answer is yes, right? So it means that it is court who will inquire that whether there is a reasonable classification or not. Now that has led to a very unique dispute saying that it have actually watered down the concept of Article 14 itself. Because it should be left open to the legislature to use Article 14 to the maximum extent. So multiple times we have got a question which says, don't you think that the principles of equality prescribed by the court has diluted the effect of Article 14 itself? You have watered down the effect of Article 14 itself. So what is the purpose of that question? They actually want to ask you, with reasonable classification doctrine, you have added something new which was not provided in the constitution, right? Getting my point? Now then the court evolved new things, right? And then during 60s and 70s you will see that they has come up with a unique principle of called non-arbitrariness. If something is arbitrary, essentially it is against Article 14. No need to go in reasonable classification. If something seems like arbitrary, now what is arbitrary? Then the court have read down multiple principles of natural justice in the process itself. And this mostly apply in the law which provides for some procedural aspect, right? Like taking away your property, granting license, granting, pension. So all those things, if the whole process seems to be arbitrary. Now how do you determine the process is arbitrary? Principle of natural justice is not followed. Then the court started to struck down, see, arbitrariness is antithesis to equality and the whole law should be held unconstitutional. Now, then the third domain of, or you can say the different aspect of Article 14 came into picture. The court started to say, see, if you are discriminating, what is the ground of discrimination you can take, right? Then the court started to read Article 15 and 16 along with it. If you look at Article 15 and 16, what does it say? So Article 14 says there can be no discrimination, but if you look at Article 15 and 16, so Article 15 says that there can be discrimination with regard to certain things, such as with regard to CST and OBCs, right? With regard to women and children, special provision for women and children. It means that Article 15 is providing for the grounds on which the discrimination can take place. Similarly, specific application is Article 16, which says that okay, discrimination can be done in the case of public employment, right? So multiple other articles, clause 4, clause 5 provides for that. Let's see, you can do some sort of discrimination. So what the general structure is, Article 14, no discrimination. If you want to do discrimination, you have to follow reasonable classification, arbitrariness. Then the court started to say that, see, the grounds which is provided in the 15 and 16 can be considered as an exception to 14. If you want to discriminate and if you want to save yourself from the Article 14, then you must be covered by any provision of Article 15 or 16. It means these are the only grounds of discrimination. Now, a very Indra Swani, a very famous case came, and there the court said that, see, Article 15 and 16, whatever the ground of discrimination is given, those are not the only ground, but other grounds can also be added, not given in the 15 and 16. So it means it opened up the horizon of grounds on which discrimination can be done, and even though it is not covered under 15 and 16, and that was referred as protective discrimination principle. If the purpose is to protect someone, any class of citizens, and Article 15 and 16 is not helping it, because the grounds provided under Article 15 and 16 is nothing, cannot be used to protect that person. You have to come up with a new ground. Then the court have allowed that, yes, even if you take the grounds which is not mentioned in 15 and 16, still the discrimination can be done as long as you can justify the purpose is for the protection. Getting my point? Okay. So these three was actually why you can say the expensive definition or understanding of the concept of equality. So, understood that particular point? Okay. बस इतना ही याद रखना है equality.